Good morning, Your Honors. My name is Erin Pogue-Newell. I represent the appellant, Eileen Diaz. May I take this opportunity to reserve 2 minutes for rebuttal? Thank you. This is a case where the trial court exceeded its discretion to dismiss an action based on fraud to the point of unjustified overkill. I want to begin looking at the standard of review. Now, this is a point that Home Depot touched upon in their answer brief, and I think they misstated the abuse of discretion review. This isn't the reasonable test of Canacaris. This court was very clear in Suarez last year in 2012, or 2 years ago, in 2012, that there's a lesser degree of difference in these type of cases, and the reason for that is twofold in this case. First, the heightened evidentiary standard that the appellees had to meet as the movants in this was for clear and convincing evidence of a scheme to defraud the court. Also, this is a case where there was no evidentiary hearing, so this court is presented with the same cold document record.
Counsel, on that issue, on the issue, it seems that in this case, or at least Home Depot is arguing, that the reason that there was not an evidentiary hearing is because one wasn't asked for until the judge had already ruled.
Yes,
Why wasn't an evidentiary hearing specifically requested? There was a 4-month period between when the hearing was set and the hearing occurred. Couldn't your client have requested an evidentiary hearing to explain the discrepancies in the discovery?
Certainly, and the appellant does take issue with that statement, the procedural history. In our reply or our response to the motion to dismiss and memorandum of law, there is a request for an evidentiary hearing. Now, it wasn't made perhaps as clearly as it should have been made, but there was a statement that an evidentiary hearing should be had as a matter of law, a citation to Medina, and that's clearly in the record at page...
It's in the memo of law. It just says an evidentiary hearing is required.
Right.
It doesn't say, and we request an evidentiary hearing before any decision.
Actually, Your Honor, it does. In the concluding section, there is a prayer for relief, and let me go ahead and turn to that.
Yes, what does
so
it
I can
say?
quote it directly.
Sure.
This was in the supplemental record. In the conclusion, it states, plaintiff has not been given the opportunity to explain the discovery violations, which are the basis for defendant's motion. The issues raised by defendant do not warrant dismissal. Wherefore, plaintiff respectfully requests this honorable court deny the request. So,
where does it? I'm sorry. Where
it's
does
not
it?
a specific request. Your Honor is correct,
okay.
and it is in a memorandum. There was not a response, a typical pleading entered, but this was treated as a response. It was clearly a response. Also, again, the burden of proof is on the movants here. This is similar to a summary judgment motion. There is no obligation for the non-moving party to file any response, quite frankly. So the fact that this was filed only 6 days, where they had only 6 days prior to the hearing, where they had a time of 4 months, that's not really relevant. And quite frankly, when it became apparent during the hearing on this motion, when the court specifically stated this is an issue of whether she, referring to Ms. Diaz, lied under oath, immediately that's when counsel said this needs to be an evidentiary hearing. Why? Because this is an issue of testimonial credibility. If you look back at that case from this court, Suarez, which is a 2012 case, it specifically talks about testimonial discrepancies and the court's obligation, essentially, to allow a party who is accused of lying under oath, the plaintiff especially, to come in and testify as to why that occurred, to explain.
But she had the opportunity. It was a 45-minute evidentiary hearing. The plaintiff could have been there.
It was not an evidentiary hearing, Your Honor. I apologize,
Was
but it
evidence
was not.
was evidence submitted?
In support of the motion, the movements...
Depositions were
the movement
admitted into
did
evidence?
submitted yes. However...
So it's not an evidentiary hearing if evidence is submitted?
There was evidence submitted, however, she was not permitted to testify live
Was she there?
testimony.
Was the plaintiff present at the hearing? Is there any evidence in our record that the plaintiff was actually present at the hearing?
There is no... well, Your Honor, maybe when I'm sitting down before I come to rebuttal, counsel may have introduced Ms. Diaz. However, I do not recall, there's no statement affirmatively stating she's here, she wants to testify.
Right.
Now, whether she was there, I don't recall, but I can check that while opposing counsel.
How would that cut if she wasn't there?
Again, Your Honor, it was requested. It was stated that an evidentiary hearing should have been had. And quite frankly, we can move on from the evidentiary issue, although this court has clear precedent stating that if there's a request, and this I still believe is a timely request made during the motion, as soon as counsel realized this was an issue of testimonial credibility, that she should have been given that opportunity in a separate, they could have bifurcated the hearing, there could have been a separate hearing where she was able to testify even if she hadn't been there. So the court should follow its precedent. And if we look at Medina, quite frankly, it's a good example because in Medina, it was remanded for the evidentiary hearing, and the court found, the trial court nevertheless again found that there was a sentient scheme, that the movements had matched their burden. It came on appeal, and again the court remanded it and reversed the ruling. We can look at the record in this case. This is actually an easy case to analyze. There's a dearth of incidences. There's only 3 incidents, 3, in the course of 2 years that we have discussed. And a handful, just a handful of alleged misrepresentations. So we can go through this quite
But they're pretty
efficiently.
significant, aren't they? I mean, in nature, irrespective of whether there's 1, 2, 3, or 7, in this case, she was put under oath. She was asked whether she was hospitalized as a result of an accident, and she said she wasn't when she was. Isn't that a fairly material misrepresentation?
Well, Your Honor, it's what she was hospitalized for. Really, if we look at the standard, it does have to be central to the case, central to the heart of the claim, whatever it is that she's allegedly concealing. So if we look at what is it that she was allegedly concealing, we can better answer that question. There are 2 incidents that occurred pre-surgery in this case, only 2. They were a 2008 car accident and a 2008 fainting spell. And we can see from the record clearly, especially when you look at that 2008 car accident, which I think is the most relevant if we're talking about relevance and if it goes to the heart of the claim. Now, that case, she was complaining of neck pain. This was a result of a 2-car accident that she was transported to the ER at Homestead Hospital. But she had the extensive scans done. Her neck was found to be normal, unremarkable. She was sent home with a pain threshold of 2 out of 10, and she was prescribed ibuprofen, Flexidril, and another drug. There's no record evidence that she actually filled those prescriptions. She was told not to go to work if she had further problems.
Well, she was at the hospital, though, but you're saying
For
she
not-
wasn't admitted for actual treatment, so
No.
she
She-
didn't think she had been in the hospital.
Well, Your Honor, she was transported. If anyone, I mean, I'm sure we've been in car accidents where we've been transported to the ER as a matter of procedure. You sit there, you talk to a nurse, you go in for scans if they make you go in for scans. She was there for 6 hours. There's no evidence that she had any follow-up treatment, that she filled any prescription, that she didn't go to work the next day. None of that was presented. Okay, so, and the fact of the matter is, 2 months later, after she had fainted and she fell onto the concrete, she didn't say that the car accident was a prior injury. She didn't say she had a prior neck injury from an incident 2 months prior. Now, the fact that the appellees try to use this as some sort of evidence that she is revealing any or concealing anything is ludicrous. This occurred in December 2008, 3 years prior to this lawsuit being filed. And quite frankly, it occurred a year, well, not a year, but 7 months prior to the accident and 10 or 12 months prior to the surgery. Okay, so the fact that 2 months after this car accident happened, she didn't subjectively believe she had been injured, I think tells the entire story there. And going back to Your Honor's question, Judge Scales, about whether that was a material misrepresentation, no, I haven't been hospitalized. Again, when we're talking about a 6-hour or a 9-hour ER visit, October and
Well,
December of
problem
2008.
The problem is it's not for her to decide whether or not she felt she was injured or not. In her deposition under oath, she has to answer the questions that are asked, and it's for the opposing side to determine whether or not to get the information to decide whether or not she was sufficiently injured to have some effect on the injury she's claiming here. So, that's the real question.
To a certain extent, I of course agree with Your Honor. You are under oath when you're in deposition to tell the truth. However, when you're asked a question of whether you've had problems with your neck, I do believe there's an issue of subjectivity there. Again, I point to the fact that 2 months after that first accident occurred, she did not believe she had had problems with her neck. 3 years later, during this deposition, I think it makes perfect sense that she's not going to consider that October 2008 incident as having problems with her neck. I also want to caution the court, as this court stated in Suarez, to look at this deposition holistically in the entire context of it. The deposition specifically, she states in the deposition that she doesn't remember going to the hospital in 2008. She says that. Counsel then presses her, so you were never to the hospital. What is she going to say? She didn't remember going to the hospital, so she's going to say no. The things she remembers going to the hospital for are the births of her 3 children. Those are several days where you're
Certainly
being
memorable
hospitalized.
events, counsel.
I'm sorry, tell me.
Certainly memorable events going to the hospital.
Certainly memorable events.
Okay,
And-
counsel, we've let you use all your time up if you want to reserve your time for rebuttal, but
I
we'll hear from
apologize. Thank you, Your
from the
Honor.
appellees.
May it please the court, Nick Mermiges on behalf of Appellee Home Depot, joined by Scott Cole on behalf of Appellee AB Fire Equipment. The first issue that I'd like to address at length is the standard of review. We can see this has been characterized in a few ways, a narrowed abuse of discretion standard. Other courts treat an issue like this as a pure abuse of discretion standard. We did file supplemental intent to rely on some recent authority, which is Herman. The one issue I wanted to note was that in Herman, the standard of review with respect to the clear and convincing question was articulated as whether the finding is supported by competent, substantial evidence. Okay, and of course, this court in Lacani said that if reasonable men could differ as to the propriety of the action taken by the trial judge, then the action is no abuse of discretion. Okay.
Irrespective of the standard of review, counsel, if the plaintiff asks for an evidentiary hearing on this issue, under Medina, aren't they entitled to one?
Well, there isn't a single case that says you're unequivocally entitled to an evidentiary hearing in this context. In fact, there's no rule, statute, or provision that requires that an evidentiary hearing be held. However, it has uniformly been recognized as the better practice. However, I would say that it's quite clear in these fraud upon the court cases in the analysis, it's a balancing test. You balance the misrepresentations, any mitigating factors, and we've even gone into the point where we're balancing the sufficiency of the hearing, how detailed was the order, how much attention did the trial court pay. And so the real question is, when you're going to sanction someone and dismiss their case, did you pay the adequate attention? Did you make careful findings? Did you consider the proper mix of factors? Did you enter a lengthy and detailed order? And in this case, of course, as was addressed by the court, no evidentiary hearing was expressly requested until the trial court had made its ruling after a lengthy special set hearing. Now, that seems to me like a heads I win, tails you lose kind of proposition, where you've received the motion, you don't request an evidentiary hearing, you go to the hearing, and the plaintiff was not present at the hearing, and you wait to see whether you're going to get a favorable ruling, and then when it appears you're not going to get a favorable ruling, suddenly now you request an evidentiary hearing. The cases unequivocally state that if an evidentiary hearing isn't requested, then there's no issue there in the sense that if no hearing is requested, then there's no abuse of discretion making an order based on the so-called cold record. The other issue I wanted to talk about...
The problem with all of these, this type of case, where someone is getting the equivalent of the death penalty in their lawsuit and not getting a trial on the merits and not going to a jury, and cutting this all off is that you've set that there's clear and convincing evidence that on the record that the individual set up a fraud on the court. In other words, this was a plan to defraud the trial court, and it's the toughest one to get because depositions, people get confused and people say all sorts of things, and you had the hospital records here, did you not? You had all of the records of this individual's hospitalizations. So it wasn't a secret that she had been to the hospital a couple of times. And so when she answered the questions, you're sitting with her documents right there in front of you. An element of fraud, if I recall, is a misrepresentation of material fact made for the purpose, which is untrue, made for the purpose of having the other side rely on which they reasonably rely. So I'm having trouble getting even over the legal issue here.
I'm glad you asked that question, Your Honor. In McKnight v. Evanchek, the court said essentially that if the misrepresentations had been successful, they would have interfered with the jury's ability to impartially adjudicate the matter. What this ultimately is, what dismissal for fraud on the court is, it's an exercise of the court's contempt
So every
power.
time that the plaintiff says the sky is blue and the defendant says, no, I've proved the sky is green, and it turns out that the defendant gets to prove, there's some mix in there about what color, and the jury could be misled as to whether the sky is blue or green, then, well, the trial judge should just decide, hey, there's a fraud on the court here. And we're not going to let you talk to the jury about it.
The issue is whether there's a deliberate scheme to defraud the court by concealing material facts. So one problem with memory, one misrepresentation certainly wouldn't rise to the standard. The standard is whether there's clear and convincing evidence of a scheme to defraud the trial court. So if there's clear and convincing evidence that the plaintiff deliberately withheld material information, then a court is well within its discretion to dismiss a matter for fraud on the court, and that reflects the fact that our entire system of civil justice requires the voluntary disclosure of material facts. So, for example, in this instance, there are no mitigating circumstances. There's no partial disclosure. So it's not as if the plaintiff disclosed that she had received neck treatment 6 times, but it turned out she'd received it 10 times. There was no disclosure of prior similar injuries, and in fact, there were categorical denials. And based on a very detailed records, very specific questions by counsel, and uniform misrepresentation.
Does hospitalization mean going to the emergency room and then walking out the same day, or being admitted to the hospital for treatment? What does that mean, hospitalization?
Well, as a preliminary matter, the plaintiff didn't request any clarification. She was also asked point blank, so you've never been to the hospital for a car
In other words, in her depo, she said
accident?
to you, could you clarify for me what you mean? This is a woman who is unemployed, and could you clarify for what you mean by hospitalization? Does that mean I went to the emergency room and got some Motrin, or I got a prescription for Motrin, and I left and went home and didn't do it? Or if I was actually admitted to the hospital, where they put me on that gurney and they take me in and admit me? Could you clarify that question for me? Was it a little bit, perhaps, a squishy question?
The totality, Your Honor, I do appreciate that you can certainly interpret, based on your own judgment, that certain questions weren't as specific as they could have been. I can tell you that the plaintiff was asked point blank, so you've never been to the hospital for a car accident. That's not the same thing as being hospitalized or admitted, okay? We have an accident that was about 3 years prior to the deposition, an auto accident. She's placed in a cervical collar and transported by EMS to the hospital. Again, recent in time, and she doesn't recall this, okay? So this is not a situation where there's a deliberate attempt to trick the plaintiff. There are point-blank questions.
So you had the hospital records there from that, though, and you didn't say so. You didn't go to the hospital in 2008 after that auto accident. You didn't ask her about, you don't have to, but you didn't ask her that, did you? You knew she'd been there.
We certainly knew she'd been there because we issued a subpoena to the hospital, the ER where she'd gone for this particular accident. However, there's a pattern of non-disclosure reflecting the fact that the plaintiff isn't cooperating with the discovery process, which is essentially contempt of court because it's a contempt of the court.
This isn't a discovery violation that you've gotten here. You didn't do Cozell and you didn't do all of that. This is a straightforward, there's several different ways you can chop this off at the legs, but that's not one of these. This isn't a motion for contempt and motion for compel and then Cozell. This is a straight fraud on the court.
Understood. And essentially what I'm saying is that there's an inherent power that a trial judge has to make sure that litigants abide by the rules. And there's certain levels of misconduct that rise. It's a kind of a sliding scale where your misconduct matches the sanction that is imposed. And in this case, we've got 3 deliberate misrepresentations. It hasn't been brought up yet that 7 months prior to the deposition, the plaintiff was in a 120-mile-an-hour car accident with no seatbelt, prolonged extraction, not ambulatory at the scene. 2 weeks later, goes to the ER and is point-blank asked whether you've been in any auto accidents after this incident. So what I would say is, first of all, you can identify specific questions in the deposition that could have been asked better. but with respect to all of the key material facts, there were point-blank, unequivocal questions, and more importantly, categorical denials. Not an I don't know, but I've never been hurt in an accident, thank God. Have you ever been to the hospital for a car accident? No. And so these are the kind of answers that reflect an intent to stymie the discovery process, to cover up material information that's essential to the defense.
You had the information, so it wasn't much of a cover-up, and all of this, you could definitely, on a cross-examination, destroy this individual had you.
So my only response to that would be, first of all, this reflects the plaintiff's non-cooperation, not the prejudice on the defense, and that was why I was emphasizing the McKnight case, because if the plaintiff had been successful, all this evidence would have been kept from a jury, okay? And the fact that the plaintiff is engaged in this deliberate scheme with no mitigating circumstances suggests that there's not going to be cooperation with discovery. So say, for example, the plaintiff did seek treatment elsewhere. How are we to know? And certainly if the plaintiff isn't disclosing this recent, proximate, relevant treatment during the course of her deposition under oath, one can reasonably assume that the plaintiff is not inclined to cooperate with the discovery process.
Is it your position that there is no way in which the plaintiff could explain any of her answers in deposition? No reasonable way for her to explain any of her answers in deposition. Is that your position?
Well, I don't want to confuse myself with the trial judge who made these conclusions. I would say that the trial judge's order speaks for itself, and to the extent that these are unequivocal, categorical denials, I have difficulty understanding any reasonable explanation that could explain away how I could have misremembered or how I could have unequivocally denied
So then there would be
something.
no harm in having an evidentiary hearing. Since if there is no reasonable explanation, then an evidentiary hearing would do you no harm, right?
Certainly at the trial level, an evidentiary hearing would have done us no harm, but none was requested. Or none was timely requested. Let me phrase that accurately and correctly. And of equal import is that one can reasonably disagree with the conclusion of the trial judge in this case, okay? But the order was clearly supported by competent, substantial evidence. And that's the standard of review for us here.
Would you agree that we give less deference to a trial court when there's no live testimony presented?
I would certainly agree with that. I would also agree that, again, at this point, there's quite a bit of law on this subject, and it's a very large balancing test, okay? So certainly having live testimony, if it's requested, and an evidentiary hearing based on that, that certainly supports a finding of fraud, but there are other issues that support a finding of fraud. There are cases where an order was overturned because a judge entered it on a 5-minute motion calendar, or where there was a one-sentence order. In this case, it was a 58-minute special set hearing, an 11-page order. If you read the hearing transcript, you'll see that Judge Cinnamon knew all of the material facts in the case and was applying the specific standards articulated by this court. And so what you have is the essence of due process, because the court was paying very close attention to the specific facts of the case. The plaintiff was on notice for a very long time, was represented by counsel, and counsel made a specific strategic choice to go into that hearing without having the plaintiff present, without in writing requesting an evidentiary hearing, and then after seeing the consequences of the court's well-reasoned order, again, based on competent, substantial evidence with no mitigating factors suggesting the plaintiff could have plausibly forgotten these accidents or any other kind of reasonable explanation, then counsel at the conclusion of the hearing says, well, I'd like an evidentiary hearing now, Judge. And that's a little bit too late. That's getting 2 bites at the apple. Again, that's heads I win, tails you lose. And frankly, given the specific circumstances of this case, relating to the evidentiary hearing, relating to the material misrepresentation, requiring an evidentiary hearing when one really wasn't properly asked for, that would be elevating form over substance. Because we certainly had a fair hearing here.
Counsel, we've let you go way over time, and I think you're repeating yourself to some extent. We understand your position.
Thank you so much.
2 minutes, counsel.
Judge Mayes, I did want to go to you first with that question about whether Ms. Diaz was present. There is no evidence from the hearing that she was present. However, there is no evidence that she was not present either. Moving on to
Except
this.
counsel, the other side probably had somebody there, and, you know, as a professional courtesy, they represent she's not there. She probably wasn't there.
Perhaps, Your Honor. I do want to move on to the partial disclosure issue. Let's point out the disclosure procedural issues under HIPAA. I mean, we are talking about medical records here. Ms. Diaz certainly did comply and aid the appellees in gaining these records. If she objected, there's actually no obligation by the hospital. The hospital can choose to withhold those records. She didn't object. She signed an authorization form. She allowed these defendants to gain access to these records. This is the exact partial disclosure that is discussed in Bologna versus Schlinger, which is the 5th District Court of Appeal case in 2008. The exact type of disclosure. If we compare this with Martizan, which is the 2009 case coming out of this court, in footnote 1, it specifically states in Martizan that the plaintiff not only failed to list doctors, but she actually falsified doctors' names.
Counsel, would you concede that there is a sanction less severe than the death penalty that would adequately remedy this situation?
Of course, Your Honor. Absolutely. And that's the court's obligation to consider that.
And what would that be?
Well, Your Honor, the court could have some sort of an instruction to the jury. Quite frankly, this is well managed through cross-examination, which this court has specifically said in Suarez. Your Honor was right about that single car accident in 2011, the one that occurred subsequent to the surgery. She clearly lied there, but this is not material to the claim. It has nothing to do with her neck. All this has to do with is her credibility as a witness, and they could have got in front of the jury and destroyed her on that issue, that one thing that she lied about, and that goes to her credibility. It has nothing to do with the liability, with the severity of her injury, nothing. That should be taken off the table altogether. Another thing that should be thrown off of this table is the alleged misrepresentations to Dr. Dare. Again, this occurred well prior to the filing of this lawsuit under Ford versus Simpson, which is a 2013 case. Any spoliation type issues that are occurring prior to a lawsuit and well prior, 7 months prior, should have no bearing on whether there's a fraud on this court. For those reasons...
Except it does make this lady look pretty not credible.
Perhaps, and you know, it's unfortunate. We have a situation where she's sitting through a 2.5 to 3 hour deposition. As Your Honor pointed out, you know, she's being asked all these questions. She's thinking fast. She's overwhelmed. What does hospitalization mean? What does problems with my neck mean? She's overwhelmed. Yes, she might have made a misrepresentation. That's something that can be brought out on cross-examination. It's for the jury to decide questions of credibility, not for the court to dismiss an action based on one lie that's not material to the cause of action.
And in closing, counsel, you would ask us to?
I would ask you to reverse the case, to reverse the dismissal of her action. However, under Medina, which is controlling case law in this jurisdiction, there should at least be an evidentiary hearing, so it should be remanded for that. Thank you.
Thank you.